Medical malpractice cases are, in a lot of respects, different than any other kind of litigation where someone gets hurt. And the reason for that is there are a host of laws that have been passed due to a very powerful lobby in Tallahassee to restrict and limit a plaintiff's ability to get justice when they have been injured through the malpractice or negligence of a healthcare provider. And, you know, sometimes at cocktail parties or out talking with my folks in the community, you'll hear about, you know, frivolous lawsuits and malpractice cases and how there's, you know, just a bunch of cases without merit that are being brought against these good doctors and with devastating consequences to their practice and to the delivery of health care in the state. And, you know, that's a message that has been put out there that, quite frankly, is without basis. And the reason for that is, you know, there are a host of hurdles that we have to overcome procedurally before we can even file a medical negligence case. We have to hire experts in the same specialty to review the medical records and swear in an affidavit that malpractice occurred according to them. And so there are a number of hurdles that have to be met before you can even bring a lawsuit. And the reality of it is that plaintiffs' lawyers, you know, are compensated on a contingency basis. They are paid a percentage of the recovery. And if there is no recovery, then there is no reimbursement for all of the out-of-pocket expenses, which can be, in terms of a malpractice case, sometimes in the hundreds of thousands of dollars, nor are they compensated for all of the time, which can be hundreds, if not thousands of hours. I don't think there's any such thing as a frivolous malpractice case because you've got all of these hurdles that you have to overcome, and the reality is that it doesn't do the plaintiff's lawyer or the plaintiff's firm any good to bring bad malpractice cases, because at the end of the day they're going to be spending a ton of time and a ton of money prosecuting a case that has no likelihood of recovery. And so, you know, the notion of a litigation crisis or, you know, a bunch of frivolous malpractice cases, quite frankly, isn't rooted in fact and is a misconception that has been intentionally injected into, you know, the discussion by special interest groups trying to limit an injured victim's ability to get justice when they have been injured through no fault of their own by a medical provider or another healthcare provider.